Good morning, good afternoon, and good evening, everyone. Welcome to our webinar. My name is Tuğçe Ergiden. I am one of the Vice Secretary Generals at the Energy Disputes Arbitration Center. And thank you very much for participating in our webinar. I would like to briefly introduce all our speakers by thanking all of them who accepted our invitation and took their precious time to participate in this webinar. Today, we have many valuable academicians and lawyers among us, starting with Mr. Orçun Çetinkaya, who is a leading dispute resolution lawyer in Turkey. He has extensive courtroom experience with a standout track record of succeeding for his clients in high-profile litigations. Also, for many years in a row, Orçun Çetinkaya has been recognized as a leading practitioner by the respectful directories, including Chambers and Partners, Legal 500, Who's Who Legal, Benchmark Litigation, Client Choice, and Best Lawyers. Also, Ms. Karina Baltic is here with us. By the way, she is the first name that comes to the mind when I think of Energy Charter Treaty. She is senior lecturer in international arbitration at Stockholm University and qualified attorney at law since 2004. At the same time, I can say that she is one of the editors in the Kluwer Arbitration. And we have Sarah Sani with us. She heads Edel Show Gather's investor state dispute resolution practice, and she's a skilled international arbitration lawyer specializing in both international commercial arbitration and investor state disputes, advising investors and host states alike. And when it comes to Aisha Law, she joined Benchmark Advisors in 2018, and she's a director and head of European origination based in London. She has an outstanding reputation in the litigation funding industry, where she originates, underwrites, and monitors funding in various litigation sectors. Also, she won lots of awards, such as the ones that you can see in her background. So we are so happy that we have her in this webinar. At the same time, she is one of the arbitrators in the Energy Disputes Arbitration Center, also one of the advisors. Lastly, we have Mohsin Patel. Mohsin is a co-founder and director of Factor Risk Management. He started his career as a litigator, working in various niche litigation practices in London. And let's start our webinar. Third-party funding is not only one of the hot topics of civil litigation and international arbitration, but also one of the legal phenomena that is still much hidden under a veil of secrecy. Despite the long-standing debate on the concept of third-party funding, this concept is still hard to define due to a lack of legal regulation and existence of privacy-oriented international practice. So I hope that today we can enlighten our viewers. To start things off, I'm gonna give the floor to Mr. Orçun Çetinkaya, and we can just discuss what are the statistics and particularities of investment arbitrations arising from energy disputes with Turkish element.
Tuğçe, thank you very much for this excellent introduction. I appreciate it. It is great to be speaking with all of you today. As Tuğçe said, I will briefly talk about energy arbitrations with Turkish elements, and by touching on to the extent possible, my time allows, characteristics of investment and commercial arbitration and their statistics. As you know, the international energy business invests in large, complex, capital-intensive projects that have really long life spans. And most of the energy projects require the involvement of more than one country and multinational energy companies. And the construction of, for example, natural gas pipelines and nuclear power plants can be given as a good example of this cross-border energy-related construction projects. For instance, when it comes to Turkey, one of the most important and recent natural gas pipeline projects is Tüpstream, which straight away connects the Russian gas reserves to gas network in Turkey. It aims to provide reliable energy to Southeast Europe and Turkey. Similarly, nuclear power plants also require the involvement of more than one country and experienced energy companies from all over the world. Again, in the case of Turkey, Akkuyu power plant in Mersin, which is still under construction, is one of the most important nuclear power plant projects in the world. This project is realized by Turkish and Russian energy companies. And apart from natural gas pipeline and nuclear power plant projects, more trendy recent renewable energy projects such as wind and solar projects are also conducted by multinational companies through the investment contracts signed by the host states. Therefore, the law that's going to apply to these energy projects having this sort of international characters cannot be limited to the laws of Turkey. Circumstances, economics, governments, and parties invariably and inevitably change in these international oil and gas projects, which often lead to disputes. The result, obviously, is that the international energy sector, along with the associated construction projects, makes up the largest portfolio of international commercial and state investment disputes in the world. And when we look at the Turkish parties with energy disputes, we don't see a picture which is different than the rest of the world. When we look at the investment arbitrations in the world, for example, we see there are around 1,100 cases, and we can say that 40% of those cases are one way or another related to energy issues. And when we look at investment arbitrations with Turkish element, we can say that there are around 78 cases, and half of those cases are again energy related. When we look at types of disputes in the international energy business, if we exclude the cases that are filed by individuals against energy companies, we can say that there are three types of disputes. And these are state versus state disputes, company versus state disputes, and company versus company disputes. State versus state disputes, these are primarily boundary disputes concerning oil and gas fields that cross international borders, and most of which are located in maritime waters. In the case of Turkey, we have seen lengthy tensions between Turkey and Greece, but that hasn't led to any dispute in any form. In the past, we have seen price review issues and arbitrations between our neighboring countries, Russia, Iraq, and Iran. And when we look at company versus state disputes, these are often called as investor-state or state investment disputes, and they occur where a foreign company invests in another company for an energy project, and when governments significantly change the terms of the original deal, or nationalize, or expropriate an investment. There is one multilateral investment treaty, as you know, of significance to the energy industry, which is the Energy Charter Treaty. Turkey is party to the ECT. Here in the ECT, the concept and scope of investment play an important role to determine whether the dispute in question can be subject to the investment arbitration. In that respect, Article 1.6 of the ECT is important. It defines investment broadly, but it is important to interpret Article 1.6 properly to make sure the investment is protected by the ECT. In addition to that, the definition of investor is important, which is made under Article 1.7 of the ECT. And equally, Article 26 is important in that it shows the way for international arbitration and makes ICSID, Ancestral and Arbitration Institute of Stockholm Chamber of Commerce available for the investors. And when we look at investment arbitrations against Turkey, we see that there are around 20-30 cases, and these are by and large construction, telecommunication, and energy. And when we look at those energy cases, we see that gas, electricity, and mining are all covered. And when we look at the numbers, we see that half of those cases are energy related. And when we look at investment cases that Turkish parties filed, we see that there are around 40-50 cases, and those are again shows a similar pattern: construction, textile, and energy. And when we look at energy-related investment arbitrations with Turkish element, we see a wide portfolio of energy issues. For example, a recent case against Romania due to renewable energy arising from changes to the incentive scheme. This shows a similar pattern to the cases filed against Spain, Italy, and Czech Republic. We see two cases against Kazakhstan. One is due to oil transportation arising from failure to make detention payments. And another case against Kazakhstan is oil exploration and production licenses. We see one case against Oman due to engineering and construction of gas projects, contracts really. We see one case against Uzbekistan, shareholding dispute in the gas distribution system. And we see one case against Pakistan, unlawful detention of electricity generating vessels. And we also see a case against Azerbaijan in connection with the privatization of long-term electricity distribution agreements. As you can see, energy-related investment arbitrations with Turkish element are wide in range, and they are following the similar trends and patterns that we see in energy arbitrations worldwide. We are gonna, my panelists are gonna touch on those. And when we look at company versus company disputes, commercial arbitrations really, I think there are two subcategories occurring between energy companies. The first subcategory could be amongst joint venture participants in contracts such as joint operating agreements, unitization agreements, farm out agreements, area of mutual interest agreements, study and bid agreements, sale and, of course, purchase agreements, and also confidentiality agreements can be listed here. The second subcategory of dispute is between operators and service contractors for the following kind of agreements: drilling and well service agreements, seismic contracts, construction contracts, equipment and facilities contracts, as well as transportation and processing contracts. These disputes, by and large, make up the majority of disputes in which energy companies find themselves. In respect of commercial arbitrations, Turkish companies are finding themselves more in the second category, in the disputes in relation to contracts between the operator and service contractors. And in that category, mostly energy-related construction contracts give rise to highest number of disputes. As you know, since Turkey is party to the New York Convention, the enforcement of those awards are going to be made as per the convention. And I am sure Sarah will have, and Frida will have more to comment on the evolution of energy-related arbitrations and the way forward.
Thank you so much, Orçun Çetinkaya. Actually, after looking at Turkey, it's time to turn to the global arbitration community. So my question is to Ms. Sarah Osani. What should investors be doing before they invest in a host country to ensure that they are able to access favorable dispute settlement provisions?
Sure. Well, thanks very much. Usually, first of all, they should be thinking about this before they actually invest. And you'd be surprised at how many investors have a dispute arise and they haven't thoroughly thought out the implications from the beginning. So I would really say there's two things that they should do. First, they should take into account the investment structure. And secondly, they should make sure that they're documenting all of the things that they're doing when they're investing in a country, all of the assurances that they're provided by the host state in order to be able to actually set forth what their legitimate expectations were at the time that they invested. Now, when I talk about structuring, our clients are very familiar with looking at things like corporate governance or tax implications. And often the reason a company will incorporate in a particular jurisdiction versus another will have to do with things like tax or corporate governance. What I advise clients is at the same time that they're thinking about tax and corporate governance, they should also be thinking about an investor state dispute resolution. So what international investment agreement might protect them when they're investing, or alternatively, if it's a private entities, is that country a member of the New York Convention? So when you're thinking about the restructuring aspect, we used to say there was always a Dutch sandwich or an Irish burger. And what you would do is you have these SPVs that you'd insert into the parent company and then the ultimate vehicle, which is usually incorporated in the host state. So you'd slot one of those jurisdictions in. The reason why we often used Irish or Dutch entities was because of the favorable bits. The Netherlands has historically very friendly bits. Usually it's just an incorporation requirement, although that has changed under the new model bit. So there wasn't too much that the investor would have to do in order to maintain premises in the Netherlands. And by virtue of being incorporated, if the relevant bit protected indirect investments and indirect investors, then you would be able to still get treaty protection. So, now it's slightly more complicated because you can no longer just say, go for the Dutch bit, because there has been a trend of host states for re-examining their international investment agreements and sometimes changing things such as what is required to be a qualifying investor under a treaty. So, countries like the US historically have always had an incorporation requirement. So literally all you have to do is incorporate in the US and then you're a qualified investor. Other countries have things like siège social, a seat, or a principal place of business. So it's important to understand when you invest, first of all, what is the requirement to be a qualifying investor? And then what do I need to do as a company to maintain that? So if I am incorporating in a jurisdiction that has a principal place of business, what does that mean? Do I need to have employees there? Do I need to have physical brick and mortar offices? Do I need to show that my board of directors is flying there and meeting on a regular basis? So these are all of the types of things that you need to ensure happens ahead of time, and so that you can get protection once the dispute does arise. I should note that once the dispute arises, it's too late. So you can't then restructure your company to get BIT protection. That would be an abusive process and abusive right. So what you have to make sure is it's happening on the front end. So that's point number one. The other thing I would just note quickly about that is, especially, Turkish bits, I come up, there's a number of Turkish bits that have quite peculiar provisions, maybe MFN provisions, for example, that they're just a little bit out of the ordinary. They've raised some issues on whether or not they apply or not and how broad they are. So in addition to the jurisdictional provisions, like what is an investment, what is an investor, you should also look at what are the substantive provisions. I mean, most ISDS claims nowadays are formed as fair and equitable treatment claims, and that's a fairly broad standard. It encompasses a variety of different strands. However, there are still important provisions like umbrella clauses, for example, and those are much more rare than your typical fair and equitable treatment provisions. So you want to also look at the substance of the bit, and then in the newer generation model bits, and then once they become enacted with certain states, are there any carve-outs for, especially when it comes to energy companies, environmental regulations, corporate responsibility? What does your investor need to do to make sure it's complying? So when a day does come where they need to raise a dispute, they will be covered. So that's number one. The other issue is really one of documentation. And that is because you want to ensure, and this has been increased by tribunals, they have increasingly required additional evidence of actually what were your expectations? What did you expect? What were you told by the government? Did it give you assurances that the regulatory framework wouldn't change? If so, how firm were those assurances? So anytime you're meeting with a government, you want to document what is being said. Obviously, two-way correspondence is better than one. It is important to understand the investor's expectations and how profitable, for example, you thought the investment was going to be and on what basis you were making those investment projections. On the other hand, you really want to have as much as you can in writing and documented about what has been promised to you. And a lot of the renewable cases that Orchan mentioned, claimants were more successful in contexts where they actually not just had a general regulatory framework that supported their investment, but also specific assurances to a particular investor. So it's not always possible. Everyone dreams of a host state that will give them a stabilization provision and allow them to, give them certain assurances in relation to the changing regulatory framework. However, if you can get any of that documented in writing, you should do so, and you should really be able to evidence what the expectation was of the investor. And then the other thing, when I've been recently engaged to advise on different structuring of renewable energy resources. And one other aspect, in addition to bilateral investment treaties or multilateral agreements like the ECT, is also what is happening in the jurisprudence. So for example, after ACMEA, now intra-EU bits are a huge problem, right? So now a lot of investors are saying, well, I don't want to have protection in an intra-EU bit because the likelihood of me being able to actually sue under that is very low. So that's a final element to check. Really, the intra-EU bits is the main focus of that one, but also there should be aware that a lot of states, especially in Latin America, have started to also terminate their bids. So you want to make sure that the bid is good, it's in force, it gives you the protection you need, both jurisdictionally and substantively.
Thank you so much, Sarah. And now it's just time to look at the Energy Charter Treaty. And as I said at the beginning, the name that comes to my mind is Karina Baltak. So I'm going to ask her the question, what are the current developments in the context of the Energy Charter Treaty? And we know that there will be a modernization. So could you please give us some information about what's happening on Energy Charter Treaty right now?
Thank you very much, and thank you for sharing the panel with my esteemed colleagues and friends. It's always a pleasure and a challenge to follow Orchan and Sarah, but I think they mentioned some very important aspects of the energy regulatory framework, and in particular at international level with the bilateral investment treaties and the Energy Charter Treaty. And we know that for some years now, we're in a formal process of reform of investor-state dispute settlement. The Energy Charter Treaty is indeed going through this modernization process. At the outset, I have to stress the fact that unlike the ISDS reform, which is quite transparent, and you find all the information on the UNCITRAL Working Group 3 webpage, the ECT modernization is not that transparent. So we have reports from time to time. For example, last week or 2 weeks ago, between the 1st and 4th of June, we had the 5th round of discussions of negotiation for the modernization of the Energy Charter Treaty, and we had the press release. So we know, for example, that 2 weeks ago, there have been discussions on frivolous claims, security for cost, third-party funding, transparency, and some general statements, but we don't know exactly what is the current state of specific provision discussed. So I think that's a bit challenging. We had last year a leaked document showing us in December how the Energy Charter Treaty looks like at this point, but we can only speculate on the discussions. So one thing that I wanted to mention is that this Energy Charter Treaty modernization process is not something new. So some might say it's related to the ISDS reform. I would say that, of course, the ISDS reform in the UNCITRAL and the ICSID amendment of the arbitration rules, they pushed or speed up the process. But if we look back in the ECT's timeline, we have a treaty that was put forward for signature in 1994. It is a European Union creation baby, and on this basis, we all assume that it will continue after this modernization process. So we have a treaty in the energy sector around for many years, and we are now in a phase of greener energy, climate change, environmental protection, and obviously, on the face of it, this treaty needed this modernization. But in 2009, you might remember that there was a proposal to modernize the treaty by Russia. And after that point, Russia decided not to become a contracting party to the Energy Charter Treaty. And with baby steps, we had in 2015 the International Energy Charter, so replacing the European Charter. And that was the starting point of the modernization process, which began formally in November 2019. In November 2019, we had the Energy Charter Conference establishing the mandate for the modernization group of the Energy Charter Treaty. Lukas Stifter from Austria is the chair of the ECT modernization group, and of course, representatives of all contracting parties. Actually, Turkey is a very active participant with interesting proposals. And when we'll discuss about third-party funding and related topics to this, I'll make sure to highlight some of these significant contributions. But as I said, we're in the 5th round of negotiations at this point, and everything is on the table, starting from the definition of investor, and Orchun and Sarah were referring to how you structure an investment and how you put the investor in the best position to have access to the benefits of the treaty. And for example, the proposed draft for the definition of investor contemplates not only incorporation, but also substantial business activities. So that's a challenge for the energy businesses to make sure that where they are incorporated, they also bring this substantial business activity, which probably will have some sort of open-ended definition in the treaty. With investment, Orchun was referring to Article 116 of the Energy Charter Treaty, but equally important and obviously one of the debated topics is what do we do with the energy materials, and that is in Article 1.4. So we have the annexes discussing the energy material and products, and most of them are the traditional forms of fossil energy. And of course, everybody wants to see the green energy, and probably will get to the discussion a bit on the cases, for example, against the Netherlands. So we have the Western countries in this phase out of the fossil fuel energy. So we have some changes there reflecting the greener forms of energy. On the right to regulate, Sarah was mentioning, is there anything in the treaty that you want to see, for example, corporate social responsibility, sustainable development? The Energy Charter Treaty, the modernized version, has everything, has the right to regulate, has the corporate social responsibility, has a very long article, a proposed article on sustainable development. So here we are in the phase of trying to, I would say, balance, but the rights of investors and the rights of the states. And I think in the energy sector, this is even more important because this is where we indeed need that sustainable development provisions. And of course, we have very new provisions like third-party funding, security for costs, frivolous claims, valuation of damages, all of which we are coming from the practice. So over 130 cases under the Energy Charter Treaty, of course, we've seen some developments. On the substantive provisions, and actually reflecting this, let's say, inconsistent practice, if one can call it this way, but in the eyes of the contracting parties, tribunals are taking different positions. The fair and equitable treatment, for example, will have the legitimate expectations on the model of the new EU treaties, which means that legitimate expectations is an element that will be taken into consideration and not a self-standing element of the or form of fair and equitable treatment. So all the elements mentioned by Sarah, document everything, make sure that all the assurances, and also making use of the other provisions in the treaty, the investors should obviously take into consideration. I'll stop here because probably we'll have the follow-up discussion specifically on the third-party funding and security for costs.
Thank you so much, Klina. Now I just want to give the floor to Ms. Ayşe, who is also one of our arbitrators, and also I will ask her two questions. One of them is that could you please give some information about how litigation funding be used in energy arbitration claims? And I would ask you to just let us see the funders' perspective. So could you please give us some information about what does a funder seek prior to funding a case?
Yeah, thank you so much, Tuğçe. Again, thank you so much for having us, and great initiative with Energy Arbitration Center, İDRAK as well. It's great to be a part of it. That's a very good question for us when we are looking at arbitration cases. When a case is arbitrated rather than going to a local court, which it can be quite challenging, it is more appealing for us. What do we look for in a case that comes in front of us? Let's start with what do we do? Why we are useful on arbitration cases? Arbitration can be really expensive. You need to pay for arbitrators' fees, you need to pay for additional costs, experts can be very expensive, Tuğçe. And when you think about Turkish clients and Turkish currency and how our currency is changing, it can be quite difficult for especially Turkish companies to match this dollar or pound request on their own. So what litigation funder does is it gives some certainty to the client. What do? We pay for the lawyer's fees, we pay for Sara Basani's fees, we pay for Orçun Çetinkaya's fees. Then we don't stop there. We go and pay Karina's fees if she's an arbitrator. And if we need an expert, we pay for experts' fees. And also, like Karina mentioned, insurance is becoming very common as well. We pay Mohsin's fees, which is after the event insurance and security for costs. So when your client starts a case, you as a client, you don't need to pay anything. We pay for everything. And what we would like to do is we would like to have a winning team, because when you sit in front of defendant with all these parties who are also speaking, and there's a litigation funder behind the client saying, we also review the case and we think this is a winner case, I think it makes client's case very strong. Other than talking about we pay for everything for the client, I think one of the benefits of litigation funding is you move the risk of losing case to a third party. How does it work? Litigation funding is non-recourse loan. What does it mean? If the case is unsuccessful, I lose my investment. So it's a really high risk profile. If the case is successful, I get certain percentage from damages. But what we do in insurance, what we do in litigation funding and insurances, we work with Mohsin very closely on this type of matters. So I provide funding. We also get after the event insurance and possibly security for cost insurance. If the case is unsuccessful, we pay for client's fees. We lose all the investment that we put in. Then insurance kicks in and they pay for the other side costs. By doing that, all that risk of losing case moves to someone else. When you think about the benefits, I would like to mention benefits as well. Then I will move to discussion about why we look. Of course, we don't put 10 million pounds in every single case or 5 million, 2 million. We have very detailed due diligence process. But before coming that, I think litigation funding can be really useful, especially for Turkish claimants. I talked about the money and talking about, when we talk about how we pay for everything, we don't need to worry about currency. But also what we do is when a litigation funding case comes in front of us, we give a third party opinion. And this is for free for the client. This might be, especially if let's think about a big energy company in Turkey, they might have 2, 3, or 4 different cases. When the cases come in front of us, we might actually save them money by saying, hey, let's say, Mehmet, you have 5 cases. Out of these 5, why don't you just invest in one case, which we think there are proofs, like Sara mentioned, there's very good documentary evidence. There are no issues on ECTs or BITs. So instead of working on all 5 cases and losing money, just put your money on that one case and we will pay for you. So actually, this is a free, I know it will sound very cliche, but this is kind of free service that as a litigation funder, we give to a client. That client can be certain on what cases they would like to invest in. And the other thing is, especially after COVID, we started to see this quite regularly. There are benefits for lawyers too. So let's say we decide to fund a case. What do? We create an SPV, we ring-fence the money, and we put it aside, which means that the budget has been saved and secured from the outset. So Sara will get her payments monthly, Orçun will work very well because he's getting paid as well. So that budget has been secured. And we also work very closely with lawyers because in some cases, if the cases are private funded, and this was raised by quite a few Turkish clients to me, Tuğçe, they said, Ayşe, we start with the budget of 2 million. We are halfway through the case, it is 5 million. So when there's a litigation funder, we usually try to control the budget. We ask lawyers to take risk on their fees. So everyone has skin in the game. So that's the benefit. Of course, when we are looking at the cases, If I fund every single case, I will be probably at home now doing my meatballs as a housewife, but we have to have a very detailed review process. So what do we look? For us, the client is very important. It should be normal, sensible, reasonable client. Lawyers are incredibly important. So there are different types of litigation funders. There are some litigation funders employ lots of lawyers, and we are a different litigation funder. We like to work with lawyers as a team together. When a case comes in front of us, we usually ask a memo from the lawyer. And while we are looking at memo, what are the things very important for us? So I will go from the back, actually. I'm not going to talk about our merits has to be great. Like Sarah mentioned, there might be some BITs. It might be unenforceable, or Karina mentioned, and we briefly mentioned as well, there might be Akmea list. All assets might be in Russia. It might be the best case in the world. It might win. It might be very successful. I can't fund that case because I am thinking like a banker. How am I going to get my money? So I always look at enforcement. Are there any issues on enforcement? Are there any BIT issues or anything? If there's nothing, great, tick. We always look at damages. It might be the best case in the world, but especially in investor state arbitration cases and ECT matters, we would like to see at least 20 million sunk costs, which means that we don't like loss of opportunity cases. We don't like to see, oh, in 18 years, this was the interest. It is 2 million, but if you would have built that place, energy place, and it was working for next 25 years, it would have been 100 million. So it's very difficult for us. We would like to see exact damages. We look at the jurisdiction. That's why arbitration is we are very favorable of arbitration, because it's easier to enforce. Recognition is easier. We look at merits, and we look at the budget. How much is a lawyer asking? How much funding is requested? So let's assume, in a very basic math scenario, damages are 10 million. We want lawyers' fees to be 1 million. So when it has to be 1 to 10 scenario, because when we get our return from client damages, what we would like to do is we also like to leave some money to client. We wouldn't like to be that litigation fund that takes all the money and client comes up with, which happens sometimes £100,000 in a massive arbitration case. We would like to have that flexibility for client. And Tuğçe, the world has changed so much. We became all very important parts of an arbitration matter, like Karina just mentioned. In working group 3, there were discussions, which I was very lucky enough to attend as well. Third-party funding has become a part of it, but also the other important part is MOSIP. So we need after-the-event insurance as security for costs. It's regularly put forward by the defendants now. I think that would be very useful. MOSIP to take us through the other leg of funding, insurance, which are two really important legs of an arbitration case.
Exactly. Thank you, Ayşe. Now I'm gonna turn to Mohsin Patel, and I have the question. And what is the after the event insurance, and how does it work? What are the options and ways to do it? Could you please give us some information?
Sure, very happy to, and thank you, Tuğçe, and for my fellow panelists for the opportunity to speak at this event. So as Ayşe briefly touched on, insurance and funding often go together hand in hand. Quite often they're seen as two sides of the same coin almost. They are seen as ways to mitigate your risk and to be able to bring claims in a measured way. Now, ATE insurance, or more commonly known as after the event insurance, is a well-established insurance product that provides claimants with protection against adverse costs. This is a critical and often used solution for litigation proceedings in common law countries where costs follow the event, but generally also in non-litigation proceedings where a claimant wishes to mitigate their exposure to their opponent's costs in the event of an unsuccessful outcome. In addition, as Ayşe mentioned and Karina also mentioned briefly, AT is also often used in combination with a anti-avoidance endorsements or a deed of indemnity as a means to defeat or resist a security for costs application. As well as general litigation proceedings, it's also becoming an increasingly important factor in commercial and ISDS claims as cost orders become more frequent. So just quoting from a report I read recently, the 2021 empirical study in costs in investor-state arbitration by BICL and Alan Novery, whereas prior to 2017, the preferred approach by tribunals was to pay your own way. Since then, there's been a clear trend of tribunals shifting to the cost follow the event principle. For example, prior to 2013, 56% of cost orders were unadjusted, i.e. parties bore their own costs. But since 2017, this has fallen to less than 23%. The report also states that cost apportionment generally has become a significantly more prominent issue in recent years. For example, prior to May 2017, of the 423 or so cases that they've reviewed, tribunals on average devoted around 10.5 paragraphs in their final awards to discuss costs. This has now doubled since 2017 to an average of 20.4 paragraphs. So in terms of what ATE is and why it's relevant, whether it's for commercial arbitration or investor-state arbitration, or indeed local litigation, that covers a few of the points. In terms of what it actually covers, touching on a little bit what Aisha was referring to in her discussion around litigation funding, ATE insurance generally is there to cover adverse costs, your opponent's costs in the event that you lose. However, it can also be used to cover your own disbursements, for example, tribunal fees or expert fees or counsel fees, as a normal part of an ATE policy. As well as the kind of vanilla ATE structure that I've just mentioned, there are also other variations to this. So, for example, you can obtain what's called own cost cover or own sides cover. And this is to provide coverage for your own costs, so your own legal fees and your own expert fees, etc. So if you lose your case, you will be reimbursed up to a percentage, sometimes as high as 90% of your own incurred fees. Now you may think, why would I, as a claimant, why would I look to obtain this product? It is quite often used in conjunction with a contingency fee agreement with your law firm. So, for example, in some cases where funding isn't appropriate or available, but the lawyers are very bullish on the case, and the claimant also wishes to progress the case, where you can convince an insurer that it is a good case worth pursuing, the law firm can have their downside protected by obtaining own sides cover or contingency fee insurance. Touching on the point that we discussed earlier, as I mentioned, ATE, the use of ATE in security for costs applications is a key use case. To give you an example, we recently obtained a policy for around $5 million for the claimant, following a successful application by the respondent for security, and that was used in place of cash and escrow. So whereas ordinarily the claimant would have had to have put in $5 million, for example, into an account, instead they were able to pay a smaller upfront premium based on a $5 million level of indemnity, and with the remaining being deferred and contingent, and the tribunal was happy to accept that as good, adequate security. So having covered what it is and what it tends to cover, lastly, when and how it can be obtained. So it's usually obtained prior to the commencement of proceedings, but it can be obtained at any point thereafter. However, the closer you get to a final hearing, the more difficult it becomes to get it, and the greater the likely costs where it is available. Therefore, it's best always to engage your brokers, such as ourselves, as early as possible, and start the process with discussing with underwriters what your requirements are. One other point I should add, in terms of the spectrum of insurance products that exists, as I've said, we've covered ATE insurance and a subset of that own sides cover, as well as security for costs. Other insurance products as well, such as cross undertakings and damages insurance. So, for example, as many of you will know, if you're looking to obtain, also if you're seeking an injunction, quite often you will be required to provide a cross undertaking in damages, which potentially can expose the claimant to a significant amount. It is possible to obtain insurance for that at quite a cost-effective rate at the outset, so you can shift the burden or the exposure of the cross undertaking to an insurer. There's also things like judgment preservation insurance. So, for example, if you obtain a successful judgment at first instance, the respondent appeals, and you want to lock in that award at the outset, that is something that is now available. And finally, arbitration award default insurance. So this is something that's used, as I say, in ISDS claims, and that protects the claimant against the risk of a win, but a failure to recover from the respondent's state within a reasonable period of time.
Thank you, Mohsin. At that point, actually, before passing to the Q&A session, I have another question to Karina. Could you please give us some information on ECT third-party funding and also security for costs?
Thank you very much, it's like music to the ears to listen to Aisha and Mohsin. And as you know, one of the very vocal cases, Escosol versus Italy, had exactly this situation of third-party funding and AT insurance on top of the bankruptcy situation of the investor. And very interesting, in 2017, when Italy requested security for costs, the tribunal took into consideration the fact that indeed there was a funded investor, there was an investor in bankruptcy, but also was satisfied that there was an AT insurance of 1 million euros placed exactly for adverse costs. That was a case, an energy charter treaty case, before under the ICSID convention and ICSID arbitration rules. And I think it's interesting to point out that both ICSID arbitration rules and the energy charter treaty are now in the process of modernization, and both will include provisions on, separately from provisional measures, on security for costs and third-party funding. And I think this comes to respond exactly to the need of having this specific legal framework included in the treaties and in the arbitration rules. But on the modernization process of the Energy Charter Treaty, is very interesting to see that there are different proposals put forward. And just in a nutshell, in 1 minute, on third-party funding, there are two proposals, one of the European Union supported by Turkey, which looks at the definition of third-party funding as a profit and not-for-profit third-party funding. The disclosure, obviously, of the existence of the third-party funding, and I think more importantly, whether the funds from the third-party funder have been irrevocably committed to undertake adverse costs liability. The proposal from the UK has the same, more or less the same definition of third-party funding, but doesn't contemplate the adverse cost provision. So I think this is relevant for the investors to take into consideration. On security for costs, there are three proposals, one of the European Union, one of Turkey and Turkmenistan, and the other of the UK. And the European Union basically has a general provision without looking at third-party funding. So security for costs, if there are reasonable grounds to believe that the investor will not be able to pay adverse costs. Turkey-Turkmenistan proposal, it's more elaborate, and there are three situations contemplated. The first one is basically where there are reasons to believe the investor would not have the funds to pay the adverse costs. The second, referring to what Sarah was mentioning earlier, the investor has structured the enterprise or divested the assets to avoid consequences of adverse costs. And the third one, which is the existence of the third-party funding, and where the funder did not undertake to commit to paying the adverse costs. And the UK provision proposal is also making a reference to adverse costs. So in any scenario, and after the 5th round of negotiations, actually it is stated that the common ground was identified as regards the provisions on security for costs and third-party funding. I guess I'll let you choose which one was selected to move forward, but all highly relevant, and we need to watch the space.
Thank you so much, Karina. I think we have received some questions now, but if you have any other questions, like having found such important and valuable names together, if you have any questions, it's time to ask. Let's start from the first question. It's from İlyas Kazem, and his question is to Saravasani. So he's asking, what happens in cases where states make promises that are conflicting with the states' other obligations under treaties to which the states are parties? And also, is the investor required to do some due diligence to be able to identify this conflict and have it resolved before disputes arises?
Sure. So I think the first question is if the host state gives a commitment that is inconsistent with its own law or the treaty. Can you, Tuğçe, can you clarify? Because I just want to get that right.
What happens in cases where states make promises that are conflicting with the states' other obligations under treaties to which the states are the parties?
Typically, so the treaties are typically speaking international law obligations that bind the host state. So it would be strange if they were to, and usually those obligations are quite consistent with what investors want. So we wouldn't typically see a host state saying, okay, we're going to do it this way, and that's contradictory to my international treaty obligations. What I was talking about when I was talking about the commitments is really trying to, because a lot of these treaty standards are quite broad. So they don't lay out exactly what you might need in order to prove your case. What jurisprudence has shown us is that the more specific and concrete the commitment from the state. So in other words, if you can get a contract with the state, if that contract can contain certain provisions like stabilization clauses or provisions in relation to, I think of the recent solar cases, the feed-in tariff. If there's an actual commitment that we're going to give you, investor X, and on that basis, you invest in my country, then that is the reliance that the investor is entitled to make. That being said, one thing that investors should be wary about is some host states will say, oh, well, this minister wasn't able to give you that, or this minister wasn't able to say that, or this department actually should have handled it and not that department. So one thing you need to do is make sure that you have local counsel at the stage of investing to make sure that when you are receiving such promises from the state, they are promises that they are entitled to give, and that the authority is there in order to give them. So that's just something that we've seen. I mean, typically the host state will encompass under international law all of its ministries, all of the entities and instrumentalities of the state. But the state might later claim that it wasn't actually bound because of internal law regulations. Now, typically a host state cannot use its domestic law to avoid its international law obligations. That's a general principle. However, it never hurts at the very beginning to avoid these pricey arguments. That's what you should also think about, is not just how to win and what is correct, but also how to avoid potential jurisdictional objections or other claims that the host state might make, which will increase the cost of the arbitration. So you should ensure that you've got local counsel, and that is part of the due diligence package, saying, oh, I wanted to invest in Turkey, and so I contacted Orçun, and Orçun provided a memo on exactly what I needed to engage with this ministry, and I dotted all my I's and I crossed all my T's. So again, that is something that you could later show as I did my due diligence, and it's consistent. Tuğçe, there was a follow-up question in addition to obligations.
Yes, it was, is the investor required to do some due diligence to be able to identify this conflict and have it resolved before dispute arises?
And what before dispute arises?
Have it resolved before dispute arises?
Yeah, so typically you should do the due diligence at the time you're deciding to invest. And I would, I always work very closely with local counsel when whatever jurisdiction I'm working on. But you should definitely get a local law opinion and local law lawyers to advise you on the commitments that the state is making and how to structure your investment. And that is something that should be done at the very outset and then kept very safe so that all of the evidence you have of the hard work that because again, these claims are based on your expectations. If you haven't done any due diligence, how do you have an expectation that you'll get something or not? You have to first understand what is required by the host state in order to have that expectation. So yes, do it at the beginning, document it, save it, and then that will be part of the case when the dispute arises, that you did your due diligence before entering into the host state.
Thank you so much. And we have another question from Alvin Shurians. Her question is for Ayşe, and she's asking, is there any indication that applying for third-party funding and having the case analyzed by an objective team can lead to more settlements among the parties?
Let's picture that. If you go in front of defendant, then you have your legal team, which is very important. But when you have litigation funder review your case, which is due diligence process, we ask, for instance, the Krinas or Saravasanis or Orçuns, top lawyers in their practice area to review the cases for us. And if the case is funded, of course, just imagine the strength that you will have when you go right in front of a defendant and you say, I have a really good legal team anyway, but this litigation funder who actually put, let's say, £5 million in my case, it is non-recourse loan, they decide to take that risk after reviewing everything. And also, I should reach out to Mohsin and Lloyd's of London decided to provide insurance. And can you imagine how strong you will be when you are discussing a case like that? You have a litigation funder who decide to invest in your case by their legal team. You have Lloyd's of London providing insurance and your legal team. That's true. There are lots of, I have seen a few settlements happened after we provide or during the course of providing litigation funding. And I think it will be more common.
If I can just add to Ayşe's comment, because I think that's absolutely true. I mean, the due diligence process that we as lawyers undertake when we are taking on a case for funding is extensive. Okay, so we don't just get the case and then send out a cooling off letter. We have to do our jobs and we have to have a comprehensive memo. We've looked at the strengths, the weaknesses of the case. We've looked at enforceability. We've looked at quantum. We've looked at all of these aspects of the case in order to satisfy Ayşe so that she gives us the money. What that has meant in practice for me is that rather than giving a one-page cooling off letter, I typically write a 20-page cooling off letter, setting out my case in full because I've already done all the legwork through the funding process. And most host states will tell you when they get those short letters that say we've got a dispute, they kind of ignore them. They just kind of put them to the side. They don't really know what the claim is about. Host states need information to settle. And one thing that you get when you prepare a case for third-party funding is information about the case. And so by sharing that with the host state, I've had 2 cases that actually they got third-party funding, but they settled before the actual arbitration initiated because we had given them so much information. We said, look, here's the case, here's the breach, we've got third-party funding, we're ready to go, we're still very reasonable, and we'd like, the other point Ayşe mentioned is cost. I mean, the average investor state case costs about $5.5 million to $6.5 million just for your fees, right? So it's expensive. So if it's a case where the quantum is reasonable, you can say to the host state, look, this is what the average it costs. We've got a great case. Here's all the information. Do you want to cut a deal now? And sometimes the host state will say, yes, let's get rid of this one. So I think that's another place where third-party funding comes in so handy because you have, experts telling you, well, what about this? And what about that? What about that? Which strengthens your case. And then you can present all of that information to a host state and therefore increase the likelihood of settlement.
Thank
And
you.
I totally agree with Sarah, and I think, Sarah, we discussed that previously as well. Sometimes they say, oh, now there's litigation funding, and Karina would remember from answer trial discussions, oh, lots of cases coming in front of states and states are spending lots of money. No, that's not true. When you look at the exit, I think since litigation funding has started, I think the case numbers were, I can't remember exact, but it was 49. It went down to 44, and then it went up to 50. So there is not a big spike because there's litigation funders sending cases. What we are doing is in favor of the defendant. We are actually killing non-meretricious cases from the beginning. So they don't need to instruct their legal team. Only strong cases are coming, and there is not crazy amount of cases now going to exit because of litigation funding. What happened is we provide access to justice. Strong cases are going in front of the defendants.
I have one question to Musin and Aisha. Musin, what is the ideal time approaching for after the event insurance? Say that we are going to get the case funded. We are in discussions with Aisha's firm. Is it better to approach you in parallel, or whether our conversations are over with Aisha? What is the ideal time? And Aisha, given the latest developments in security for cost issues that as Karina explained, as far as I know, previously, insurance was an element for litigation funders to change the pricing. What is the situation right now?
Shall I go first? So thank you. That's an excellent question, Orçun. So different insurers have different approaches and different ways of looking at things. But if we were to take kind of a broad generalization, most insurers, underwriters, like to see a case where they know that a funder is involved. They like to see it virtually when it's almost at investment committee approval stage. Most insurers simply do not have the resources that most funders have in terms of manpower, personnel, in terms of the ability to look at cases. Obviously, the pricing structure is very different as well. So they're not
investment committee stage of the litigation funder.
Of the litigation funder, yeah. So as in, it's pretty close. I mean, don't get me wrong. From our perspective as a broker, we like to get involved as early as possible because we can help shape the overall presentation and the overall narrative. I mean, I'm not going to overplay what it is that we do, or overstate it in any way. But the reality is that, having a certain, narrative and presenting risks in a certain type of way, can provide the incremental kind of gains or the incremental kind of improvements, which can mean, the difference between a case getting successfully insured and one that's not. And also, you've got to remember that historically, ATE insurers or the ATE insurance market, yes, it's a market that's been around for probably around 20 years or so, but historically, it started off in the small insolvency, personal injury type space. It's only in the past, I'd say 5 to 7 or 8 years when funders in the UK particularly have become significantly more prevalent, and where the risks have changed from the small end cases to now significantly larger, whether it's group litigation in the High Court or whether it's investment treaty arbitration. A lot of that has been led by funders, and insurers have had to kind of almost catch up. So the insurance market has had to develop. It's still not as sophisticated as the funding market in terms of resources, personnel, and so on and so forth. So they do tend to they do tend to lean quite heavily on funder assessments. So if we are to take a case to an insurer, I mean, firstly, from a lawyer's perspective or from a claimant's perspective, the same information that you will be providing to a funder, the insurer will want to see anyway. So everything from your case assessment, your legal analysis, anything on enforcement recoverability, the budgets. So when you have all those things ready for the funder, that you should absolutely also engage with the brokers and also get those documents in front of the insurer. But to actually get the insurer to a position where they're ready to say yes or no, you can almost guarantee they'll want to see what the funder says first. But occasionally, what we try to do is make them dovetail together, because what you don't want is a funder that's ready to go and then an insurer that's still having to play catch up. generally speaking, insurers do tend to be a little bit more efficient than funders in terms of timescales. And I say this, by the way, I say this as a former funder myself. So, but I mean, as I say, that's because they're set up very differently. So, sorry, I hope that answered. That was a long-winded way of answering your question.
It was very clear. Thank you.
Because they piggyback us. So we do the investment. You guys sit there, you're like, oh, I should think this is a good case. Okay, what is the premium? So, no, I totally agree with Mohsin. And it is for us to fund the case, we don't have a time limit. If the case is very early stages, sometimes we meet clients and then the case starts to build up. And we are interested in that type of cases as well. And there might be a case already going through tribunal, or there's an appeal happening, or damages stage. We don't have any timeline to say, oh, after this day you can't apply for funding, because it's a different risk. We do pricing differently. And like Mohsin said, when a case comes to us now, we straight away instruct the broker to see if there's insurance for it. Because for every single ECT or exit case, now we have a budget for security purpose. So we need to get green light and the pricing from insurers. We put that one in the budget. That's why it's very important for us to work with brokers.
Thank you so much. And we have another question from Peter Farman, who is also one of our consultants at the Energy Disputes Arbitration Center. So on security for cost cover, the premium is presumably a sunk cost, whereas the security is only a cash flow issue, assuming the party is successful. So what is the rough percentage premium range?
Yeah, Shah, I'll pick that up, Shah. So I mean, look, it's again a very good question. I think implicit in that question is the assumption that the claimant actually has the money to put in to deal with a security application. So I think first and foremost, an AT policy combined with a deed of indemnity or an anti-avoidance endorsement is a good substitute, and sometimes it's the only substitute. For example, if you have a 5 or 10 million security application against you, unless you have 5 or 10 million to put into an escrow account, your only other real option, I mean, yes, there are, bank guarantees and bonds and other stuff, but generally speaking, your only realistic and efficient option is to get an ATE policy with a DOI or AAE included. And the cost of that, yes, there is a cost of that, and I'll come on to that in terms of percentage premium range in a second, but it will be cheaper than putting in 5 or 10 million or whatever it is the whole amount is. And of course, putting that money in, as Peter's quite rightly put, only in quotation marks, so he obviously understands this, but there is of course an opportunity cost to putting 5 or 10 million into an account which can't be touched for potentially, the arbitration experts here will tell you, but 5, 8, 9, 10 years potentially. So that's a lot of money to have tied up for quite a long time. So I mean, just in terms of conceptually dealing with that, in terms of the cost of the premium range, you'll appreciate it does range depending on the type of case, the size, the risk type, etc. But I mean, typically in terms of the upfront cost, and there is usually an upfront cost and a deferred and contingent cost, so you only pay that as and when you're successful. But for the upfront non-refundable element, you can look for anywhere in the region of, let's say, 10 to 20% of the level of indemnity. So if it's $10 million that you're looking for, it may cost you $1 million or $2 million in premium upfront, which is non-refundable. So it's not cheap, relatively or speaking, or comparatively speaking to other products, but it is it's risky business. Not every insurer will do it, so it's quite a confined or restricted market, and that obviously, and of course the risks that you're looking at, they tend to have binary outcomes themselves. So that is reflected in the pricing. I hope that answers that.
Thank you, Mohsin. Unfortunately, we have lots of questions coming through, but the thing is that we have lack of time. But I'm going to ask the last question to all panelists. Will litigation funding be standardized and uniformed in the near future? If the answer is positive, will soft law or hard law legal instruments solidify this practice, its features, and requirements to practice litigation funding? Simon Zibilovic is asking.
So can I start with that from a litigation funder's point of view? I don't think so. Because if they say these are the rules and you need to follow that, then there will be no flexibility of litigation funder and be creative. Like Mohsin mentioned, we are evolving quite quickly. There are lots of different cases coming. And since I have been in litigation funding over 10 years now, it has changed so much. The cases has changed, the appetite has changed, and they can't create a structure saying you need to look at that, this is this, that's that, this is the answer. Litigation funding doesn't work like that. Litigation funding is you need to think on the spot, be creative. It involves investment banking, insurance. So which side of litigation funding will be, let's say, uniformed? Then you don't need different litigation funders. You have one fund, will give money to everyone, but it doesn't work like that. Every funder is different. We have different creativity, and I don't think it will work for litigation funding. But the general, like Karina was mentioning, general aspects about the security for costs and different parts, maybe, but they can't unify litigation funding.
Can I just add something to that very quickly? So in terms of standardization and uniformity for litigation funding as a concept, I mean, I'm not sure you kept that's possible, but I mean, there are certainly aspects of it that can, and there have recently been some efforts by some parties to try and standardize, for example, some of the documentation. So for example, the litigation funding agreement, I mean, I've so quite often we'll have 3, 4, or 5 of these on the go at any one stage, and they are all very, very different. And they all have, they look at things in a slightly different way. And, some of that is a reflection of, the parties' intentions and what it is, but quite often it's just different drafting styles from different lawyers. So, there's definitely a degree of standardization that could be placed in terms of funding documentation, priorities, agreements, and that sort of thing. I mean, it's not, to give you by analogy, AT insurance policies, yes, insurers have their own policy wordings, but the level of difference between them in terms of, it's minuscule. They're very, very often, I wouldn't say copy and paste because that would be unfair, but they are very similar usually, and you just don't have that kind of level of uniformity in funding. And I think that's only a good thing for funders, for lawyers, for claimants, for the market overall, if we do have a greater degree of standardization, because it's, as I say, mark of efficiency and all that sort of stuff. So yeah, that's just my little comment on that.
I might just add one point. I think you do have to look at the jurisdiction that you're doing business in, because the rules, at least for lawyers, in terms of how we can enter into risk sharing agreements are different by jurisdiction. So if I'm in the US and I've got an LFA governed by New York law, that's going to be different than what I can do under UK law. So you do have to have, you do have some framework within which you have to act. The other point I would just note about standardization, I hope not. Aisha is one of my favorite funders because she's so creative and she always comes up with really interesting ways of how to fund things. But I would note to just, investors and other lawyers, not all funders are created equally. And so it is important, just as they do due diligence on your case, to do due diligence on the funder. Some of these guys, aren't as well established. Do they have the money? You can ask that question. Show me the money. Are you putting my money in a special SPV, and will it be set aside for the entirety of the case? Because imagine the consequences to your client if you all of a sudden, get halfway through the case and the funding is gone. It's dried up. They ran out. They went out of business. And this happens. So you need to also ensure that the funder is what you want them to be. I remember quite a popular funder in the London market said that when this person started the funding shop, they gave away the same $10 million to about 20 different people, and which is funny. They were successful in the end, but that would not be funny if they were not successful and then that pot dried up. So you really should inquire of your funder, how will the money be placed? Is it protected? Is it, set aside and ring fenced so that other people can't dip from my pot and then take that money? So that's just the point I would make. When you are seeking funding, you should do your own due diligence, vice versa. A lot of times people are so excited to get it, they forget to ask the questions and they just assume funders have money because they're funders, which they may or they may not. So do your due diligence on that as well.
Just to add a 1 second line to that, to Sarah's comment, because I can see Karina was going to say something. It's third-party funding. It's really important to remember is still an unregulated market. So yes, you do have certain funders that may have, they may subscribe or they may submit to the FCA rules in respect of certain things, or they may hold a consumer credit license or whatever it is. But by and large, the funding market is unregulated. So, you kind of, for all lawyers out there, kind of, caveat emptor from the very outset, I'd say. Sorry, Karina.
No, I was going to say, thank you, Mohsin. It's a great introduction to what I was going to say. I think we need to look at the litigation funding from two perspectives, the one of the funders and the one of the litigation or arbitration process. Because as Mohsin was saying, there is at the most self-regulation in most of the jurisdictions. And I think this is where we're going to see maybe the next developments. Once the third-party funding is growing in importance and volume, then we'd probably see some regulation out there. So that's one point. When it comes to the litigation arbitration process, we do see some standardized language around in the arbitration rules and treaties and so on. But obviously there are so many new situations in practice that will still have to be addressed. For example, the standing of the investor or the funded party in the proceedings, and many other points that probably we'll see in the future. So I think it's an evolving market. The last point is another space that you want to watch in respect to third-party funding is the relation between the funder and the funded party. We see in practice quite few arbitrations arising out of this relationship, and I think this is a growing market. But I'll stop here.
Thank you so much. I think we have really been able to delve into some of the key issues. And to be honest, this is really what I wanted to achieve with this webinar. Third-party funding is obviously sometimes quite an obscure and sometimes misunderstood field, and I'm so glad that we have been able to illuminate things for our viewers. So I'm very grateful for all our speakers to share their views, and we had the chance to learn each of them's perspective. I guess this was so informative. And thank you so much for our audience to just attend to our webinar. And it's lunchtime in Turkey, so thank you so much. And I'm looking forward to the next EDAC webinar. Thank you.
Thank you, Tuğçe, for organizing, and also the attendees for staying on and asking some very good questions.
Thank you so much.
Thank you, everybody.
Thanks, everybody. Have a great day.
Bye.